Welcome back to Estate Planning 101. This is attorney Thomas Burton, and today we're going to be discussing why a will alone is not enough to avoid probate in the state of Wisconsin and other states as well. So while you may hear that it's a good idea to have a last will and testament, and I generally recommend this, many people are surprised to learn that a last will and testament alone will not avoid probate. I sometimes have people contact the office and tell me they would like to set up a will so they can avoid probate. They've heard the term avoid probate because many people either have experience with it or they've heard about it as a court process, a time-consuming process that involves a lot of paperwork and fees, and they know there's many reasons to avoid it, and that's why there's a lot of literature out there talking about avoiding probate. But there's also a lot of general estate planning articles talking about making a will, because we know many Americans never create a last will and testament at all. So while it is a good idea to have a last will and testament in place, the will itself does not avoid probate. And that's why today I've created this illustration here where I'm going to walk you through why a will alone does not avoid probate. And the difference is, you'll see on the left here, we have the last will. And a will is a document you create during life and you sign in front of two disinterested witnesses. The will is private during your life, and you can revoke or amend it at any time. In contrast, a trust is similar. It's also a document you create during life. And if you create the most common form of trust we use is what we call a will substitute. It would be a revocable trust or revocable living trust, meaning you create it while you're alive and it's revocable at any time during your life. Both of these documents, you'll see here I have a black line after death. Both become irrevocable upon death. So if you die, you can't change your will anymore because you can't execute a new one. And similarly with a trust, once you are dead, generally you are the only person who has the ability to revoke or amend the trust, so the trust would become irrevocable. The difference is after death, what happens? The will must be presented to the probate court. By law in Wisconsin, the personal representative has 90 days from knowledge of the decedent's death, the person who died, to present the will to the probate court, and they must file it. At that point, the will becomes a public document on file with the probate court, and anyone can view its contents. By contrast, a revocable trust keeps things private after your death. It's a private document during life up here, and it remains private after death, because a trust falls under contract law instead of the laws regarding wills. In fact, we have our own trust code in Wisconsin, as do many states. And generally, after you pass, the trust becomes irrevocable, but it remains private. The only people who have the right to see the trust would be the trustee, the person named to administer the trust after your death, and then beneficiaries named inside the trust generally have the right to see the trust. By contrast, a will, you have to notify all interested persons in your estate. This can include not only people named in the will, but it can also include, like, let's say you name your spouse or children or your nieces and nephews and some charities. They would all have to get notified about the will. But it can also include a niece or nephew you didn't leave in the will, because if you had died without a will, they would be your natural heirs under the intestate laws. So this definition of interested persons does not just include the people listed in your will. In fact, if you are planning to leave your estate to someone other than the natural heirs under the intestate statute, like let's say you have 3 children and you want to leave it just to 2 of the children and completely cut out 1 child, then I generally recommend not using a will at all, because if you have your reasons for not leaving 1/3 to that child, when the will gets filed, they would still have to be notified as an interested person, and that at that point they would have the opportunity to contest the will. So the more you alter your disposition from whatever the legislature has laid out in the statutes, the more interested persons will still need to be notified, even though they are not named in the will. And what happens is they get a copy of the will and can read it, and they see they are not named. And you know your heirs the best. Some people can understand this and respect your wishes. Others do not and think there's maybe a reason they should have been named in your will. By contrast, the trust remains private if you don't name someone as an heir in the trust, as a beneficiary. Then after you're gone, they generally have no rights to see the trust because they were never named in the trust in the first place. That's one major benefit. Another one, the big one we talk about a lot, is avoiding probate. So as I just said, the will, by definition, must go through probate court. So you must file the will within 30 days, prove the will. So you have to prove it's a valid will signed before 2 disinterested witnesses, notify interested persons, generally by mail. Then those interested persons either have to consent to the admission of the will, or there has to be a hearing regarding the will. Now, a lot of estates in Wisconsin are handled informally, and if everyone will sign a waiver and consent, you can admit the will without a hearing. This is the best way to save money on the estate administration because it can be done with the probate registrar as an administrative hearing. However, if even one person refuses to sign or just never returns that envelope in the mail, you will have to hold a hearing to prove the will before a judge. And along the way, you have to pay a filing fee to the court to take care of your affairs for you. So the way this works is the courts are overburdened as it is. They have a lot, unfortunately, of criminal matters to deal with. So the probate court has been set up to deal with probate if they have to. But it's not a free service. They charge you fees to do so because they pay a staff to administer the probate office. So you will pay filing fees based on the size of your estate, as well as newspaper publication fees. And what often adds up is a fee to the lawyer, billing hourly, in Wisconsin, generally hourly, to take care of your estate. Then after the estate paperwork is filed, and just a reminder, it isn't as simple as filing one piece of paper to open a probate. It generally involves from around 6 to 12 different forms that need to be filed at the beginning to get things rolling. And it depends on the amount of interested persons and the heirs and the estate. But even a small estate, unless it's under $50,000, even a smaller estate, the paperwork burden is significant. So I tell my clients, I have to do all of this paperwork for you, regardless of whether you have $1 million or $150,000. The price, the time to prepare all that paperwork isn't significantly different at the outset. Then you must notify creditors by filing notice in the newspaper, and that newspaper will charge you to file this notice. You've maybe seen it when someone passes a small notice. Creditors generally have from 3 months to 4 months after that's filed to present a claim. By contrast with the trust, you can choose to file a notice to creditors, your trustee, if they believe there's outstanding debts. They want to set a time period, but they're not required to do so. And both the will and the trust, after you pass, your personal representative under the will, that's the person named, sometimes you'll hear them called an executor in another state, or your trustee under your trust will have to obtain a tax ID number, EIN number, for either the estate or the trust. And that's because after you're gone, all income or expenses earned by your estate under the will or the trust over here will have to be filed on a tax return with the IRS if there's more than $600 of income in the year. Now, some estates and some trusts don't have that much income because they mainly exist to distribute the assets after you're gone. And if there isn't a business or other entity throwing off income, sometimes they don't have to file this tax return. But in either case, you will need to get the EIN. This is not a big burden itself, but for probate, you have to file all the paperwork and get appointed personal representative and then obtain the EIN. Over here, as soon as you pass, your successor trustee will step into your shoes and they can file for this EIN. And that, in my experience, is relatively simple. They can either contact a lawyer to help them get the EIN, or some people are savvy and can do it on their own. So once you have the EIN with the trust, you can keep administering the trust because generally the trust already has the bank accounts retitled in during life. So up here, if you set up a trust plan, for instance, with my office, I'm going to recommend you retitle the real estate and retitle the bank account into the trust. What this means is when you die, there's no freezing of the bank account. Whereas with a will, as soon as the bank knows you're dead, they're going to freeze the account until your personal representative gets appointed by the probate court. And just to be clear, getting appointed by the probate court doesn't often happen in like a week later. It's more like 2 to 3 months later they could get appointed on average. And if it's contested, it will take much longer. Over here, your trustee, successor trustee, the bank would already have the accounts titled in the name of the trust. So they would just need to present the trust to prove they're the successor trustee and perhaps a death certificate to show why they're stepping into your shoes, and they could continue to administer the trust. So for avoiding probate, the trust is much more seamless because a trust is designed to be set up during your life and can continue after your death. Whereas with a will, there's this very bright line difference between life and death, and after death, all these steps have to be taken with the probate court to administer your estate. So if you have heirs, spouse, children you trust who you want to administer your estate privately, consider using a trust because it will be much less burden and paperwork burden, time, and expense for them after you're gone. The successor trustee takes over the bank account and they can sell the real estate if it's retitled already into the trust as discussed up here, because many people express to me, I want my house sold after I'm gone and I don't want my son or daughter to have to wait a long time to do so, because they realize there's holding costs to holding real estate, such as property taxes, maintenance, and expenses. So the way to do this quickly is to hold that real estate in a revocable trust. Then your successor trustee can clean out the house and get it ready for sale as soon as possible. Now, in my experience, if you have the estate set up in a revocable trust, your successor trustee can often wrap up everything in 1 year or less. A trust can go longer if you design it that way and want it to last for a few years, but for a lot of my clients, the main reason is to avoid probate, pay expenses, wrap up the estate, and then distribute the assets to their heirs. And in that instance, it's certainly very possible to wrap up the administration in 1 year or less and file one tax return at all if necessary. For a probate process, 1 year is generally the minimum you're going to get it wrapped up, and sometimes it can take 2 years, or if it's contested, even longer. So I hope this video gives you a useful overview of the difference between using a will-based plan or a trust-based plan for your estate. If your primary goal is to avoid probate, then I would seriously consider looking at a revocable trust-based plan so that your heirs can have a private administration of your assets after you're gone. As always, thank you for watching and thank you for tuning in. I hope this video has been helpful to you, and we'll see you next time.